stretch for this chapter. We have a section here on civil rights as opposed to civil liberties, which we did back in the winter. And then that'll be it for judicial branch. As I said earlier, there will be no quiz on this. It will be on your final, but no specific quiz on the judicial branch. Instead, what we will do is you guys, as you can see in Classroom, will turn in your notes. If you took your notes by hand, then what I would ask that you do is just take a picture or two of your notes so I can see that they are done and send those to me via either Remind or my email, and I will put those in for a grade instead. But like I said, home stretch here. So let's get rolling. Up at the top here, we have my dude Lyndon Johnson signing the 1964 Civil Rights Act, which will be integral to basically everything we're going to talk about today. A lot of the cases that we talked about back in November, December, into January were first half of the 20th century, really kind of up until the Johnson administration, and then a couple afterwards. Virtually everything we're going to talk about today, with the exception of like 2 or 3 cases, is going to be somehow a result of civil rights legislation signed in the mid-60s by Johnson. So, what are civil rights? Civil rights are specifically aimed at protecting a certain group of individuals. What that group is, usually in the context of the cases we're going to look at today, is based on race or on gender. Whereas civil liberties, which we talked about earlier, are protections from the government. So think of civil rights as protecting against discriminatory action, so singling somebody or some group of people out because we don't want to allow them to do X, and saying that's not okay anymore. Whereas civil liberties, we're saying the government is trying to stop everybody from doing this. That's not okay anymore. So hopefully we can see the difference between those two. Civil rights are a specific group or protected class, whereas civil liberties are the government is trying to deprive people of something. Next, if you're denied access to that law, to which other groups have ready access, then we're looking at more of a civil rights issue. Because as we said, civil liberties is basically everybody. Civil liberties is broader just because it's usually going to be like, hey, this person hung a communist flag, but if we stop them from hanging up that flag, then it becomes a slippery slope, where civil rights is basically more along the lines of, we're not going to allow women to work in this job, we're not going to allow African Americans to vote, that sort of thing. The big question that the Supreme Court is always going to ask when we're dealing with civil rights is whatever denial of the rights or benefit that is being given to a specific group, is it reasonable? Usually to rectify a problem. So thing X was done in the past that was bad. By fixing it in whatever way now, are we doing it in a reasonable manner? This comes out of 2 things, basically. The 1964 Civil Rights Act, which is, as I said, our picture above, which is going to outlaw discrimination. Initially, it starts out with just outlawing racial discrimination. It's going to add women in as well. So women in racial groups are the protected classes there. That is also why you still see Supreme Court cases that deal with LGBTQ rights, because there is question as to whether it falls under that, and if it's, especially if it's just a sexual orientation question, it doesn't really fall under a protected class as it currently stands in U.S. law. So hopefully that makes sense. As always, leave questions if you have any, and I'll answer them. If we don't have any questions, then we can keep plugging. It also is going to work on unequal voter requirements and doing away with those. The CRA and the VRA are sort of steps that are taken to the 24th Amendment. It's also going to outlaw poll taxes. The CRA is also going to take steps towards doing away with segregation in more places. Basically, anywhere there's any sort of government oversight, segregation is going to go away there as well under the Civil Rights Act. Now, 1965, the follow-up after Johnson is reelected, is called the Voting Rights Act, the VRA. And this is going to go further into ensuring that minorities of all sorts have absolutely the same rights as, white men who'd had those rights already. And it's also going to take some steps to adding federal oversight to voting. And I say some states, that is my polite way of saying pretty much the American South. The rest of the country largely had their ducks in a row at this point, and the American South in the 1960s, as we all know, not exactly the most progressive place. All right, moving on. The big thing we want to get into here is desegregation as it applies to civil rights. We've got two big cases here. We've got Brown versus Board and Swan versus Charlotte Mecklenburg. Brown versus Board we've talked about before, so I will keep this brief. It is a pair of cases in the 1950s that will be decided twice by the Supreme Court. It's actually a bunch of cases bundled together. Brown versus Board is just the one that we refer to. Little background on the case. Brown's daughter is going to a school that is something like 16 blocks away from their house, but there is a perfectly good school, only for white people in Topeka though, like 4 blocks away from the house. And he says that this isn't fair, and the Supreme Court's going to agree with it. A large argument is going to be based on a psychological study, actually, that shows that desegregation leads to a lower self-image in children. Segregation leads to a lower self-image in children and therefore is harmful to them, and thus the government has a compelling interest to get involved. That argument, legally speaking, kind of a stretch, but it worked. So, don't argue with success. Topeka had essentially gone out of its way to stop Miss Brown from attending a school that was closer to her home, which didn't make sense. So schools were inherently unequal. The Supreme Court is going to make a unanimous decision. As we talked about in the last set of notes, a 9-0 decision is set in stone. And Earl Warren spent a long time making sure that he was going to get all 9 judges to agree with him that there would be no reversal on this case. Now, years later, now that this is sort of policy, we're going to see a flashpoint. And that is Swan versus Charlotte Mecklenburg Board of Education, 1961. So this is in North Carolina. And what's happening here is schools were essentially segregated even though they were desegregated. What does this mean? It means that the way the town had been set up, or the towns had been set up, and the districts had been drawn, is that even when they desegregated, you were seeing schools that were 95% white or 95% black, and then the quality of education in those schools within the same district was dropping off because the school board was choosing to heavily fund the white school, whereas the black school was again getting deprived. So it was segregation by another name, essentially. So what was decided upon was busing, which means that African American students were going to be bused to the white high school and white students were going to be bused to the African American high school, with the intent of evening out the racial disparity within those schools. And people had an issue with this. They're saying, hey, it's just where people live. The districts had been drawn, so deal with it. And the Supreme Court says, no, this is still a fix for segregation. So if you want to include quotas that say you need a certain proportion of the state population, so say the state population is 55% white, 45% black, then the schools should be representative of that within the district. Or the district population is, 45% black and 55% white, then the school should definitely do that instead of a 95-5, 5-95 sort of thing. So you can do quotas to make sure that the schools are okay. You can redraw districts within the state if you want, and you can bus if both areas are segregated. This worked out relatively well in North Carolina until the 1990s. And the reason it stopped working in the 1990s was it became a much more diverse area in the 1990s. Is a number of Asian immigrants and Hispanic immigrants also moved into North Carolina and basically made it more of a racial melting pot. And so the district backed off of that. Busing didn't always work. I'm not going to get into it now, but if you look up like busing wars almost in Boston, and I think it's the late 70s, there's some cases where it doesn't work and it results in riots instead. But constitutionally speaking, busing is okay if both areas are segregated, and to combat segregation, you can have student racial quotas or redrawn districts. So there's our look briefly at desegregation. We're going to keep rolling here. Now, These slides might look familiar to those of you that spent a little more time in the civil liberties stuff back in first semester. I pulled these out of there just because we didn't have time to do them then, and these are important. These are also civil rights cases, and the rest we touched on were civil liberties cases. So, two things here. One, you get Title VII. Title VII under the 1964 Civil Rights Act says you can't discriminate in employment or education based on race. Let me be clear here. Title VII corresponds with race, whereas Title IX, which we are all probably much more familiar with as it applies to high school sports, and you've heard it a million times. Title IX is also part of the 1964 Civil Rights Act, but that one says you can't discriminate in employment or education based on gender, which means for every male sport, you need a corresponding female sport. So you can't have a high school sink all of its money into just like a boys football team and spend nothing on anything else. It needs to be equal, which sort of explains why if you look at like the sports at this high school, why, you know, we have a softball team and not a baseball team that is compensating for, you know, essentially wrestling. Whereas we have girls volleyball here, that compensates for football. The bigger your high schools get, the more sports you tend to have. So for example, the high school I went to, we had more sports. So we had softball and baseball. We had guys and girls volleyball. And the thing we used to compensate for guys football was a bowling team. But Title IX is going to deal with that sort of stuff in both employment and education. So the relevant bit of text in Title IX, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. And because every public school in the country is taking some form of federal money based on grants, there you go. And those schools that, for whatever reason, aren't, can't really sidestep this because, A, they're a public school, so they're basically being forced to take that money by the state, one would assume. And also, they wouldn't be allowed to participate with the rest of the district if they all of a sudden added in a bunch of sports and didn't have the other ones there. So, you know, it's set up at the federal level here, but the states sort of police themselves on this as well, and very rigorously. Next up, these cases might sound sort of familiar. These are all cases from the last 40 years. All right, so our first one up here, and this is one I'd like you to know here, is the Regents of the University of California, Davis versus Bakke. This takes place at the Cal Davis Med School. Bakke applies to get into the med school and doesn't get in, ends up applying something like 4 times and does not get in, and argues that this is happening because there's a quota system in place at Davis Med School that says they want a specific number of minority students there, and Bakke is not a minority. So what they'd been doing is this was basically a checkbox on the application. And when the people were going through looking at the applications, they'd say, oh, okay, this person's a minority, we'll check that off. And if you had a certain number of checks, you were moved to the front of the line. The Supreme Court says this is not okay. It can't be a factor in admissions. So it can't be an actual checkbox. But it can, however, be considered. So if it comes down to, do we want this one person or do we want a minority, then the people can think about it. They cannot mathematically, if you will, base their decision on race, but they can consider it if there's a tiebreaker. Now, next up, City of Richmond versus J.A. Croson. The City of Richmond had a policy in the 70s that said they wanted to give 30% of all city contracts to minority business owners to rectify, Virginia's centuries of racial discrimination. This is what is called reverse discrimination in some cases. And they were setting aside those jobs, which is why I have setting aside there. Long story short, it's illegal. The Supreme Court says you don't really have this based on any sort of math. It's just because you feel bad. and you are not doing the best for your constituents, because if you need to pull 30% of those contracts from minority business owners, you're not spending tax dollars appropriately, essentially, is you are not doing your duty. So you can't just reverse discriminate and say it's not discrimination. It still is. You are still giving benefit to a group, even if that group, in the case of J. Croson, is a minority. Next up, Gratz versus Bollinger. This is at the University of Michigan. And what's going to happen here is when you applied, rather than it just being a checkbox like we saw at UC Davis in Regents of Cal versus Bakke, what Michigan is doing is they are saying, are you a woman or are you a minority? We're going to throw 20 points to you. And what happens is they go through this entire application, and whenever you meet specific criteria, so you've worked somewhere before, you have a certain GPA, you have a recommendation from this group of people, whatever, you would get points for it. So essentially 20 points are being added to that overall score if you are a minority. And the Supreme Court is going to say here that ranking in school applications is straight up illegal. It grants a quantifiable advantage. So it's the same thing as it being a factor up here. So again, it can be considered, that's not going away, but any sort of quantifiable advantage for a minority is unconstitutional. It can't be done. Now, this next one is going to bug a lot of you, and I completely understand why. San Antonio Independent School District versus Rodriguez. What happens here is this bites. As we know, education is largely paid for by property taxes. And what happens is some towns around San Antonio have very high property taxes. People living in the cities themselves have relatively low property taxes, and especially in San Diego, we're pretty low income. And what was happening was there was a very clear delineation in the quality of schools. Is the people in one county who were paying very high taxes had a really excellent education program, and their kids were doing very well, whereas the people in the San Antonio Independent School District were doing quite poorly. They did not have enough money to cover books, things like that. The schools are decrepit. The kids, as a result, were not receiving as good of an education as the folks out in the burbs. And the Supreme Court essentially says, hey, education is state policy. There is no constitutional right to an education, so we can't step in here. Yeah, it sucks that there is that giant disparity in quality of education within a couple miles of each other, but at the end of the day, that comes down to state and local government, and the feds can't get involved here. Education's a policy, not a right, even if it harms someone's ability to learn. That one's no fun. Okay, this will be quick because we've talked about a number of these already, and it's the last one is the only one you're not familiar with. Plessy versus Ferguson is what starts out segregation. Homer Plessy is a biracial man in the 1890s, gets on a train at the behest of what will sort of become the NAACP later on, specifically to get arrested, to show that the segregation policy enacted in the state of Louisiana about train cars is not fair. He makes a point of this. He purposely gets arrested. It takes him a while because most people on the train don't really care. But eventually he gets arrested, and the case makes it all the way to the Supreme Court as it was intended to. This is what you call a test case. And the Supreme Court instead says, actually that Louisiana policy is fine. Separate but equal is fine. Now, as we know, that's going to get overturned, but that's where it starts. Sweat versus Painter is a much more uplifting case. Long story short, guy applies to go to law school at University of Texas, Austin, and he is admitted in, but he's admitted to the black law school as opposed to the white law school. The black law school has about 3 teachers to the 30-ish that are there at the white law school. They have about a library of half the size, and he doesn't get to go to class with his white compatriots. He instead has to go to this tiny little decrepit classroom on his own. So he sues the University of Texas, and the Supreme Court agrees with him and says you can't deny college admittance based on race, and separate but equal in colleges is equally unacceptable. Separate but equal being unacceptable is thanks to Brown versus Board of Ed, which we have talked about before. Plessy versus Ferguson, the separate but equal policy has no standing in public schools. Brown versus Board is followed up a year later that says schools must desegregate with all deliberate speed. A good number of schools will follow along with this. Sometimes people like Dwight Eisenhower will have to step in and force it to happen. Sometimes you'll get stuff that happened in South Carolina and Virginia and Alabama, where schools will for years close down and just create private schools where all the white kids go and just not have a public school or a terrible public school that receives virtually no funding that only the black kids go to. If you're interested, when we get back, I have a book on my shelf that I'm looking at right now as I record this called Something Must Be Done About Prince Edward County that does a very depressing job at showing what that looked like for education in the 60s and 70s and into the 80s before it finally stopped. Now, this is another bummer one, but it's the last of these equal protection ones on race, and this is called Milliken versus Bradley. And there are two types of segregation. You have de jure segregation and de facto segregation. De jure means legalized segregation. So a law being passed that says, African Americans not allowed to go to school here. So if you specifically spell it out in a legal sense, that is de jure segregation of the law. De facto segregation is a different story. De facto segregation means that as people move into a city, they tended to congregate near other people like them. So when the Great Migration happens and tons of African Americans leave the South, they move into areas like, let's say, the south side of Chicago or the city of Detroit itself. They're going to move in near other African Americans who share the same cultural background as them, same values, same religious beliefs, all that sort of stuff. And white people that lived there are going to leave those areas, it's called white flight, and move to the suburbs. So maybe these are two neighborhoods right next to each other. You have the city African-American neighborhood, and right outside of it, you have the white enclave. So again, we'll use Chicago because I'm familiar with it. If you look at a map now, you've got the city of Chicago, and then you've got Cicero. Cicero is the white enclave. The city of Chicago has the African-Americans living in it. If, according to Milliken versus Bradley, there is a law that says only white people can go to the high school right on the border between Cicero and the city of Chicago. Only white people can go there. That would be unconstitutional. That would be de jure segregation, and that would be a violation of the law. On the other hand, if it is de facto segregation and the school district is just drawn, or had been drawn rather, with borders that only saw white people going to this high school, it's unfortunate, but it is legal. So that is the crux of Milliken versus Bradley, is de jure segregation, so actually writing out only group X gets to come here, that is illegal. Whereas if it just so happens that only group X goes to that high school because of the way the districts shape up or the way neighborhoods work out, it's unfortunate, but that is legal. So the two I want you guys to pull from this one, though, you're already familiar with Brown versus Board. I do want you to be familiar with Plessy and what that says, and also with Milliken versus Bradley. I realize you're probably asking, hey, what about the last slide? So let's check it out, and which ones do I want you to know here that might pop up on the final. In this case, I want you to know the difference between Title VII and Title IX, and these two, Cal versus Backey and J.A. Croson. So race can't be a factor in admissions, and reverse discrimination is not okay. Okay. Last slide for the judicial branch. When you are done with your notes, remember, either screenshot the handwritten ones you've done, or if you did it on a computer, turn them in on Google Classroom, and I will throw a grade into the gradebook for you. Okay, so let's wrap this up. Equal protection for gender. Craig versus Boren we've actually talked about before. Craig versus Boren is the 1970s case where Oklahoma passes a state law that says girls can buy alcohol when they turn 21. Girls can buy alcohol when they turn 18, but guys have to wait until they turn 21. So, Supreme Court here says that, hey, this is straight up gender discrimination. You can't just allow one person to have access to one thing and not another based solely on gender. That's the key there, is Craig versus Boren specifically says that because it's based on gender, it's a violation of the 14th Amendment, which is that equal protection clause. Next up, VMI. VMI, for those of you who don't know, is the Virginia Military Institute. It has been around forever. It's basically like a private version of West Point. So it's a military academy that is also a college. Women in the 80s started applying to VMI, saying, hey, we want to go in, get this education, then go into the military after this. And VMI says, no. But we know we'll get in trouble if we just say no to you. So we're going to create a women's VMI. Will we put it in a strip mall? Maybe. Will there be 3 people at it? Maybe. But you'll get to go to VMI, small parentheses, for women. And then we will have done our due diligence. And the federal government comes in and says, no, there's no good reason for this other than, ooh, girls, icky, they have cooties. You need to let women into VMI. So VMI is going to have to do this. The Citadel, which you may remember for almost beating Alabama for an entire half of football last year, will follow in suit. Next up, this is one I want you to know here, Johnson versus Transportation Agency. What happens here is Johnson is a guy. He applies for a higher job within the state transportation agency in like California. And he loses out on the job to a woman who's been there for a shorter amount of time. And he says that he was discriminated against. And the agency had a policy in place that said, we look to have it about 50-50 in management positions between men and women at some point in the indefinite future. And when the court looked at this, they said, well, it looks like she's about as qualified as you, maybe not as qualified, maybe hasn't been there quite as long, but she can clearly do the job. So what they agree here is if everyone is equally qualified, then having an affirmative action plan saying that we want to promote minorities, then that's okay. And when I'm saying minority here, I just mean like not the majority of white men. So basically you're not a white man, affirmative action would be okay here to promote you over said white man if they were equally qualified or nearly equally qualified. Next one, you don't need to know it, but I think you'll find it interesting. Reed versus Reed. In Idaho, there was a state law that said if there was a question as to who got to execute a contract, preference should be given to men. The Reeds got divorced. Their son had passed away as an adult a couple years before the divorce, and they were still administering his estate. So they were still paying for stuff. They still had inherited money. They were still distributing stuff. And so Mr. Reed says, well, clearly, as a man in Idaho, I am the one that should be administering his estate. And Mrs. Reed, the soon-to-be ex-Mrs. Reed, says, like, no, I know what I'm doing here. I know the ins and outs of this more than you do. You should let me administer the estate. And the Supreme Court is going to agree with the soon-to-be ex-Mrs. Reed. Mandating the choice of any gender violates the 14th Amendment. It's not reasonable. Both of them are equally qualified to enact that law. So by having it spelled out that men need to be given preference, you are discriminating against the women and unfairly. Next up, this is another divorce one, Orr versus Orr. Alabama had a law that only required men to pay alimony, even if they were making less money than their spouse. So what Orr versus Orr says is there's no male role in society, and so courts can't create one that says men have to be the breadwinner and provide for their spouse. So that law is thrown out, and at this point in Alabama, if a couple got divorced and the woman had been the breadwinner in the family, then she would have to pay alimony to her ex-husband as opposed to the, less income ex-husband having to pay alimony to his wealthier ex-wife. Okay, Rosker versus Goldberg. This will sound familiar to you. This goes back to almost the very first thing we talked about way back with civil liberties. Is the draft gender discrimination? And the Supreme Court says no, because the government has a substantial interest in that men's bodies are more suited for war. Therefore, they can choose to exclude women from the draft. Simple as that. Substantial government interest. And the last one, and the reason Danny Glover is here, is Massachusetts versus Murguia. Murguia is a firefighter. He's a police officer. And he is 50, which is the mandatory retirement age for law enforcement officers in Massachusetts. He does not want to retire. He says that he is not, in fact, too old for this, and he should be able to continue to do the job. And the state says, you know what? You might be able to, but for the most part, 50-year-old police officers are not as quick on the draw. They are not as fast. And thus, that causes an issue of public safety. And if public safety is in question, you can mandate retirement. So, Mr. Murguia, we're sorry that you are all over this, but we are going to retain that retirement age at 50. And thus, that's okay. That's just there because I didn't want to make an entire slide for age discrimination, because that's literally the only one we're going to talk about. All right, that's it. Ladies and gentlemen, we are done with the judicial branch. Wrap up those notes, get them in. Enjoy your spring break if this is the last thing you're doing. If you have yet to watch the video for the Loving story, Loving versus Virginia, on voodoo.com, there's a link to that on Classroom. Go ahead, watch that, do the vocab and the questions that go along with it. The PDF is just there if you want a little more background on it. But knock that stuff out. And then enjoy your spring break, which at this point I can only assume is driving you all insane. And hopefully I see you guys back here in April. If that is not the case, then we will go through the legislative branch next. So get hyped. Keep washing your hands. Don't gather in groups outside, but, please go be in the sun for some amount of time. Have a schedule. If you haven't read it yet, read that article I sent you guys on Remind, all that. And I'll talk to you soon. Bye, folks.